And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the January 13th sitting of the Appeals Court. My name is James Lemire. I'm joined this morning by Justice Ditkoff and Justice Grant. We will be hearing 6 cases this morning. If you'll notice where the court seal is, there will be a timer there that will count down the 15 minutes for each side. There will be no rebuttal. I'll call the first case and we'll begin the argument. The first case is 2020 P303 Commonwealth versus Javier Pimentel. Ms. Leary.
Thank you, Your Honor. May it please the court, Catherine Leary on behalf of the Commonwealth. The Commonwealth would respectfully request that the court reverse the allowance of the motion to suppress, which was allowed because the necessary witness was not present. As an initial matter, I would like to alert the court to what appears to be a gap in the record. It is transcript, the December 12th transcript 2019, page 10 onto page 11. At the end of page 10, the judge is speaking, and then on page 11, he goes into his findings, and at the very bottom of page 10, there appears to be, the transcriptionist states that there's a gap in the audio, about approximately 20 minutes. Unfortunately, I noticed this gap in preparation for oral argument late last week, and I apologize for that, but I did reach out to my brother who was counsel at the hearing, and it is our opinion that this is not a significant gap that will preclude the court from deciding the issues on appeal on this record, and we state that because it appears what will be missing would be counsel's argument regarding potential prejudice to a continuance being granted, and the prejudice raised in his brief and the prejudice addressed by the court in its findings are the same. So I did want to alert the court to that and apologize, but we believe that the court can decide the case on this record.
And just to clarify, is that at RA 70?
I believe it's in, yes, I believe my, 6. I'm sorry, can you repeat the page? The record
70?
appendix number?
The bottom of page 70 of the record appendix?
Yes, it is, Your Honor. And it just, my eyes went over it and I do apologize. But counsel and I are both in agreement that the record is sufficient for the court. But I just did want to alert the court to that. And so the issue here is whether or not it was an abuse of discretion for the judge to decline the Commonwealth's request for continuance and grant the motion to suppress. When determining whether to grant a continuance, the court should be looking at the movement's need, the cost, the inconvenience, and prejudice to the defendant. Here in this case, the Commonwealth's need for the continuance was great. Absent hearing on the motion to suppress and allowance of the motion to suppress, the Commonwealth, it's tantamount to dismissal with prejudice for the Commonwealth on the criminal charges. All that would be left that the Commonwealth could go forward on are the civil infraction of speeding. And when viewed in light of that, with whether or not I think the cases in CLARKE, Borders, and even Burston are clear that you're looking for whether or not there's egregious misconduct by the Commonwealth or serious prejudice. Here, it's clear from the record that the Commonwealth and the prosecutor acted diligently to procure the witness for the hearings. The officer was summoned and was made aware of these hearings at each turn. And this is not a case, unlike Burston or other unpublished cases, where the court has upheld a judge's discretion allowing the motion to suppress in these circumstances, where it was clear the Commonwealth simply didn't summon the officer and didn't act diligently to have them appear. I'd also note that allowance of a motion to suppress in circumstances like this also would turn on whether there's serious prejudice to the defendant. And while there is prejudice, as my brother noted, by the fact that a criminal case is pending, I don't think that rises to a level of serious prejudice that it's not unique to this defendant. And also I would note that in this case, while there were some two continuances because of this officer, there were also a number of continuances because the defendant hadn't filed a motion to suppress for some time, and also due to court congestion. So I think on the facts of this case, it was an abuse of discretion.
Counselor, is there any reason why the judge couldn't have issued a dismissal for want of prosecution? That, of course, obviously would have been without prejudice.
I think the judge could have done that, and the Commonwealth could have brought back its case and then continue with the motion to suppress. I think if the motion to suppress had been allowed, then even the case was, that's tantamount to a dismissal with prejudice. If the case was essentially dismissed without prejudice, then it would stay, and then the Commonwealth's against the Rule 34 clock of 36 clock, excuse me, of bringing the case back, and would still be able to go forward on a motion to suppress if they brought the case back.
Along the same lines as Justice Ditkoff, it would seem to me, I was actually more surprised at him allowing the motion instead of just dismissing. Maybe I'm missing something, but it would seem to me that there was nothing before the judge other than an affidavit of the defendant, which only raised the issue of a hearing for him to have a motion to suppress. I suppose the Commonwealth not proceeding, I mean, I just don't know how the judge could make any findings on the motion.
Yeah, yes, Your Honor. I had the same thought, and I think, well, unfortunately in the Commonwealth's position, but I think under Burston, which is cited in my brief, where a defendant has a motion and has a signed affidavit that transfers the burden to the Commonwealth for proving that the stop or the constitutional issue was permissible. And in Burston, the court said it was not, that it's permissible to allow a motion to suppress in these circumstances because the Commonwealth hasn't met its burden. Because I also had the same thought, but my understanding of the case law, especially under Burston, is that once the burden shifts to the Commonwealth and the Commonwealth doesn't produce evidence, then it's permissible to allow the motion to suppress, unfortunately, in the Commonwealth's view, but I believe that is the law.
Thank you.
If the court has no further questions, I'm happy to rest on my brief.
I see no further questions. Okay, thank you. Attorney Osborne.
Thank you, Justice Lemire. May it please the court. Good morning. Michael Osborne on behalf of the appellee JAVIER Pimentel. I think my sister nailed the issues that is before the court right on its head. In the appellee's opinion, this does not constitute an abuse of discretion by the trial court judge because he did take into account the factors of prejudice, took into account his control over the court calendar in a busy court such as Lynn District Court, and he took into account the fact that this was not a dismissal / allowance of a motion to suppress after the initial hearing. This was the third time the Commonwealth was seeking a continuance for the same reason. The second time the Commonwealth was seeking a continuance based on the unavailability of the only officer involved in this case, which I think severely puts it, and it's very analogous. It's contrary to the facts in the Clegg case, where the Clegg case, that dismissal came about after the first request for a continuance. And I think if this was the first request for the continuance, we're in a completely different arena and with the Commonwealth in a much stronger position from an abuse of discretion standard. But in this situation, I don't believe the facts before the court would allow it to conclude that the trial court's decision was outside the range of all alternative or reasonable alternatives. We need to give deference to the trial court in the abuse of discretion standard, and I don't think this decision is a clear error of judgment, is arbitrary, is capricious, is whimsical or idiosyncratic, which the LL case cited in my brief outlines. I think we can't ignore the fact that the trial court was kind of hamstrung by another trial court judge's decision to mark the case in the docket no further continuances. I think that fact the lack of detail that was presented to the trial court judge with respect to why this officer was absent, I think goes into the analysis as well. So
Well, if it turned out that Judge Howard Hogan marked no further continuances just because she was having a bad day and not because of anything the parties did, would that be an abuse of discretion for Judge Archia to rely on that and essentially dismiss the case and deny the motion to suppress?
I think in that situation, if there wasn't good reason for Judge Howard Hogan to mark the case no further continuances, I think him just relying on that and not considering the facts of why we had a continuance, then yes, I do think that would go in the Commonwealth's column to strengthen their argument. But I think in her view, I think it was not an abuse of discretion on her part to mark the case no further continuances. It was the second request from the Commonwealth for a continuance. She allowed that continuance, and as a result of allowing that previous continuance, she marked it no further continuances, which I think was a reasonable action.
Why couldn't Judge Archia respect the no further continuance order by just dismissing for want of prosecution?
I think he could have, but I also don't think it's an abuse of discretion for him to allow the motion, given the case law that my sister correctly pointed out. I mean, it's not outside reason for him to allow the motion. I mean, the court had before it a properly filed motion to suppress supported by a legal memorandum as well as a signed affidavit from the defendant. And with that, the burden shifts to the Commonwealth, and Judge Archia determined that the Commonwealth was unable to satisfy its burden and therefore allowed the motion to suppress. Yes, is it harsh? Certainly, but I do not think in this situation, given that it was a third time that this was requested, is an abuse of discretion. And if there are no further questions, I as well would rely on my brief.
All right, seeing no further questions, cases.
And we are back live and on the record.
All right, good morning again. This is the case of Commonwealth versus Jason Galvin, docket number 2019 P1702. Mr. Murphy.
Thank you, Justice Lemire, and may it please the court. My name is Brian Murphy, and it is my privilege to represent Mr. Galvin in this appeal. This is an appeal from a jury finding that was a split verdict. This can only be characterized as a compromise verdict, as the counts that they found guilty and not guilty don't follow any logical trail to the evidence. He was found not guilty of 2 counts of indecent assault and battery, and he was found not guilty of 1 count of intimidation of the witness, and he was found guilty on the remaining counts that were submitted to the jury. The first issue is one that I can deal with fairly briefly because the Commonwealth has conceded it, which is that he was initially charged with 1 count of rape of child and 1 count of aggravated rape of child. The interesting thing in this case is that the offending period spanned about a year. And in the middle of that year, on October 22nd of 2008, the aggravated rape statute became effective. So what is unusual about this case is that the testimony involved allegations that occurred over a year-long period, but the indictments themselves were clearly bifurcated on the October 21st date. The Commonwealth was forced to do this if they wanted to have a conviction with the new aggravated provision, which included a 10-year minimum mandatory sentence. And so that is how they proceeded. The problem was the jury was never instructed as such. And so the jury was never told that that October 21st date was important because if he was found guilty of aggravated rape and it was based on conduct that predated the effective date of the statute, that would be violative of the ex post facto clause.
Well, as you said, the Commonwealth has conceded that. They suggest that the underlying offense of rape should stand, though. Do you agree with that?
I do not. I think that in this case, both of the rape counts must be vacated and remanded for a new trial. And the reason is because of the way the Commonwealth elected to bring this case. One of the cases that the Commonwealth relies on is Commonwealth v. Campiti, which is 41 Mass App Court 43. And in that case, as in a number of the cases that the Commonwealth discusses and that I reference in my brief as well, it is clearly established that the date of the offense is not an element, such that if there is a change in the indictment on the eve of trial, as was the case in Campiti, this does not prove problematic because the date is not an element of the offense. However, in this case, rather than charging a course of conduct, which is how these cases have been traditionally presented to both the trial and the appellate court, most of the time the indictments say from date A to date B, rape, and then count 2 from date A to date B, there's an allegation of rape. In this case, the Commonwealth elected to proceed differently. And they proceeded on the idea that there are 2 distinct time periods at issue. And so one of the indictments said February 12th to October 21st of 2008. And the second indictment said October 22nd to June 1st of 2009.
Well, then the prosecutor asked the judge for an instruction to clarify that at some point, didn't she?
There was a discussion, or not at the time of the jury instructions themselves, but earlier on, where both the judge and the prosecutor recognized that this was something that would have to be clarified in the instructions. It was then forgotten about.
Right. So didn't defense counsel waive that by not raising the issue at the charge conference or at the charge?
I don't think it is waivable because if he was found guilty of a crime, in this case aggravated rape, that was not a crime at the time that it occurred. That's violative of the ex post facto clause and is not waivable. So it would have been better practice for defense counsel to raise it at the time of the charge conference for sure. But in this case, it's not a waivable mistake because it's simply not a crime at the relevant time period. So the issue here is, unlike all of those cases that the Commonwealth cites, they did not charge a course of conduct. They charged 2 distinct time periods. And it's, I think, instructive to look at what the court said in Campiti about if that had occurred. And in Campiti, they talked about it is theoretically possible that someone could be charged with 2 crimes. And the example that they gave was an armed robbery. If someone commits an armed robbery on week A and then commits an armed robbery on week B, and then the person is charged with an armed robbery on week B, and evidence of both of those crimes is presented, that conviction could not stand based on it could have been either of those armed robberies. And that's the case here, is that if they had charged a course of conduct, the Commonwealth would be right. That the remedy, if they had charged both of them as the beginning of the offense period to the end of the offense period, I would concede that the correct answer is to remand for resentencing on the lesser included offense. But in this case, that's not how the Commonwealth elected to proceed. They elected to bifurcate and indicate 2 different offense periods, necessitating an instruction that clarified both of them. So in this case, the jury was faced with the prospect of, here are 2 crimes that occurred during time period A and time period B. And then they weren't properly instructed about that at the end. And so we don't know if in fact we don't know what they did. We don't know if they found that the rape all occurred in the second time period or all occurred in the first time period, or that they most likely, based on the lack of instruction, this was not a point of discussion at all. In that case, the only remedy to effectuate a fair result is to remand for retrial on both counts. My second point that was raised in the brief is the issue of Dr. Brock's testimony. Dr. Brock testified as an expert about delayed disclosure. And there are a few infirmities in her testimony. The first is, and the most important is, that her testimony directly endorsed the alleged victim in this case. And so what happened is, this occurred on redirect, and I think Attorney Townsend pointed that out in his brief, is on redirect, the Dr. Brock was walked through the exact testimony of the alleged victim and said, does this track? Does this make sense? And that is exactly what the appellate courts have said you cannot do. That this testimony is, and I concede readily that testimony of this nature, the appeals court has said is admissible. It is an appropriate use of expert testimony, provided that it doesn't come too close to the line of endorsing an alleged victim's testimony.
Are those cases about endorsing the alleged victim about expert testimony on direct, or are there cases that say that they can't come too close even on redirect?
So in my research, there was not any dicing out of those 2 points. And that is the point that's raised by Attorney Townsend in his responsive briefs. And I think you could ask him, of course, but he cited no case that distinguished them. And I found no case that distinguished direct and redirect.
What exactly are the questions you say were tracking?
So she was asked, the example was, Dr. Blocker was asked, is it normal for delayed disclosure when the abuser is a parent figure, which is what was the case here? Is it normal to have a 6 to 7 year delay? Is that fairly common, which was the case here? Is it, if disclosure to a parent as opposed to a peer, it was common, because on direct, she had said the typical disclosure is not to a parent. And in this case it was. And again, she said, yes, that is appropriate and common as occurred here. So the challenge is that what Dr. Block did was effectively say, in her direct testimony, she said something that is basically everything is normal. And I think her testimony, my second concern with her testimony is that it went beyond what expert testimony can do. And for example, she testified to things that are not facts, that she conceded were not facts. For example, she said the average time for disclosure was 2 years. Then a couple of sentences later said, actually, we don't know if that's true.
Where exactly did she say that? I had trouble finding that.
It's Record Appendix 3, pages 251 to 252. And when you continue to go through her testimony, what is remarkable about it is that it is replete with probably, it is possible,
Right.
it can vary.
3 what?
251 to 252.
All right, and where does she say, I don't know if it's 2 years is the average?
I have to pull the Record Appendix up. I don't have it open in front of me, but I will do that now.
Well, she talked about the fact that some children never complain, right?
Yes.
And then she said something about the average, or maybe she said the mean is 2 years, but since some never complain, you can't really have a mean when there's some people never complain.
Exactly right. My concern with her testimony, my main concern with her testimony is that it directly tracked, that redirect portion that directly tracked the testimony. My secondary.
But she was cross-examined about the fact that she knew nothing about this case.
Correct. I don't think that opens the door. The fact that she knows nothing about this case doesn't mean that she then gets to learn about it on redirect. And so I don't know how the defendant could open the door to say you now are allowed to vouch for the victim by crossing her on things that were not particular to the case, which is what the cross-examination in this case was. The cross-examination sought to point out the other shortcomings of her testimony, the fact that she was relying on not a particularly scientific method, that she was making assertions about the prevalence of certain types of disclosures without knowing exactly, Justice Grant, your point is that if you don't know the denominator, you can never offer a reasonable probability of when somebody is going to report. And that was her point, is that I can't really say. If she can't say, why does she get to say it all? Why do you get to say, here's a statistic that I don't believe it, that I don't believe is accurate. I don't think it's true, but I'm going to give it to the jury out of the mouths of someone who is cloaked in the authority of being deemed an expert witness.
Again, where does she say, I don't think this 2 years thing is true?
I'm happy to follow it. I don't have it in front of me. I'm happy to follow up with a follow-up letter if that would be of assistance. I'm looking for it right now. I have it as my notes said it was the Record Appendix 3, pages 251 to 252.
Part of what's confusing is that there's copies of the trial transcript in the appendix, which is not what Rule 18 contemplates in a criminal case. So we have multiple copies of the transcript that's numbered differently.
I apologize for that. That was, we resubmitted the record appendix as in conjunction with the motion for a stay. And that I think that was done inartfully on my part, so that it ended up getting submitted twice. I'd spoken to the clerk and I'd hoped I'd figured that out, but I may have done that incorrectly. So I apologize for the confusion there. But the main concern with Dr. Block is not the fact that her testimony is largely based on non-scientific, non-expertise suppositions that she has about her and feelings that she has as a result of her work. It's that it directly tracked what the alleged victim said. And so the main complaint here is in line with the cases that have said this is not allowable, is that she directly tracked what the alleged victim said on redirect, and that is violative. That goes beyond the pale of what is allowed in an expert testimony. And it's very limited area where we have allowed an expert to come in and say that a defendant's behavior could be within the realm of possible reasonableness. So I think that is the main concern with Dr. Block. Finally, the third point that I raised in my brief, and the Commonwealth correctly pointed out that this forum does not have the power to resolve it, is the first complaint issue. First complaint is, I think, something that is, the case law has been moving in a direction that makes Massachusetts not in the two least restrictive states in the country to be using first complaint, but I can see that this court doesn't have the power to change it. I included it as the court has recognized I should in Commonwealth v. Doobie because it is prudent to include it in a direct appeal if you seek to bring it up as a further appellate review. If there are no further questions, I would rest on my brief.
If we did have the power to abolish the first complaint doctrine, would that mean that defense counsel would be precluded from cross-examining the victim about why she didn't tell her grandmother for all those years, or her mother?
I think the answer to that is yes. What is interesting about first complaint is that there are versions of it, and in my brief, there's a 50-state survey that goes through the versions of first complaint in all 50 states. And we are in only two of those 50 states that allow the broadest use of first complaint, which is that the complainant can testify as to the subject of the conversation. The first complaint witness can testify as to the subject of the conversation, and there's more or less no limits on that. There's only one other state that has such a broad version of first complaint.
Did you happen to look into whether there might be states that have something analogous to first complaint that call it something else?
So all 50 states do. There's something analogous, and they have different versions, and that they are discussed in my brief. The question is how broad the doctrine should be, and whether it should apply to all cases and all of the conversation between both the alleged victim and the first complaint witness. We really are an outlier on that, and I think the SJC has recognized that and has started to. This doctrine has started to change. But while I find this a fascinating topic, I recognize that I'm in the wrong forum to raise it.
Thank you.
All right, there being no further questions, Attorney Townsend.
Thank you. May it please the court, Thomas Townsend for the Commonwealth. Unless otherwise directed by the panel, I'll address the issues in the reverse order as my brother, beginning with the first complaint issue. And as I noted in my brief, this court lacks any authority or power, obviously, to reverse the Supreme Judicial Court. But also, it's worth pointing out that the King decision, the SJC employed its superintendent's power, which this court also lacks. So this court is doubly deprived of the power to reverse the King decision. And also, interestingly, in King, because it was a superintendent's decision, it was prospective only. So King himself did not benefit from that decision. And the defendant, I submit, would not benefit from this decision. And a third point, which I made in my brief as well, is that this was never raised below. This is the first time we're hearing of it. It was an interesting point raised just a moment ago. Would defense counsel be precluded then from trying to take advantage of the absence of first complaint doctrine? And interestingly, in this case, if you look at the closing argument, the defense attorney did argue the delayed disclosure. It said there was no disclosure in 2008, no disclosure in 2009, no disclosure in 2010. So there was some, and I think we would expect defense counsel to make such arguments. So I'll just, with that, I'll pass on the first complaint issue. and turn to Dr. Block's decision. Dr. Block's testimony was really generic, run-of-the-mill delayed disclosure testimony that's been allowed in Massachusetts since at least 1989 in the Dockham decision. And Judge Carey here has discretion, and he exercised that discretion. The defendant would have to point to an abuse of discretion on Judge Carey's part for allowing evidence which has been allowed in Massachusetts since 1989, has been sanctioned by the Supreme Judicial Court and this court in many decisions. She did not link her testimony to the victim in this case. Now, the defendant in his brief relies quite extensively on the Rather decision from this court. Well, Rather was a decision which involved a defense witness who had examined two of the victims. And then on cross-examination, the prosecutor took that expert and made him an expert for the Commonwealth, in effect, and solicited that testimony. And this court said the primary vice with what occurred was that that expert had examined two of the victims. Here, the victim, or excuse me, the expert knew nothing of the case. And that was brought out on cross-examination by defense counsel. So this is a far cry from Rather. And this was ordinary, generic, run-of-the-mill, delayed disclosure testimony that has been sanctioned over and over by this jurisdiction's appellate courts. Turning to the vouching just briefly, there was no objection by defense counsel because I think she recognized that she had opened it up on cross-examination. She emphasized that there was that the average disclosure was 2 years. And obviously to draw the inference that this is not a typical case. And also she emphasized that it's ordinarily to appear, and here it was apparent. So the prosecutor, unless she's going to be totally handcuffed, was allowed to ask the simple questions. Well, is 6 or 7 years unusual? Is disclosure also to apparent something that's seen? I think that's fair game. And to handcuff the prosecutor would be tilting the scales. And I think there was no objection by defense counsel because she herself recognized that that was fair game.
So you think it would make a difference whether that was brought out in direct examination or redirect?
I think so, yes.
So in other words, if the prosecutor had brought that out in direct examination, you might say there was error.
Well, I think if the prosecutor led the expert and fed the expert the facts from this case, knowing that the expert knows nothing about this case and only through pitches having to do with this case, that would be inappropriate. What the prosecutor did here, by contrast, was solicit the broad information on delayed disclosure and only got specific, not mirroring this case. It was an 8-year disclosure in this case, but the prosecutor asked about 6 or 7 years. But in disclosure here was to apparent, not appear. But I think the prosecutor is entitled on redirect examination to just briefly touch on those so the jury's not left with the impression that this is just a crazy case and this was not something that's typically seen. I think that was fair game. I think defense counsel recognized it as fair game. Unless there's any further inquiry on either of those two issues, I'd like to turn to the lead argument having to do with how the two rapes were handled in this case. The Commonwealth indicted on 2 rapes. If you look at the indictments, it is a time range, and this is page 4 of Record Appendix 1, where for the lead indictment, it said diverse dates between February 12, 2008 and October 21st, 2008. And then for the second indictment, the aggravated portion, it's diverse dates between October 22, 2008 and June 1st, 2009. So obviously that was to take advantage of the aggravated statute that had been passed at that time. The problem here, as has been acknowledged in both briefs, is that although prosecutor and the judge discussed how to handle this, and the judge at one point said the verdict slips would reflect the dates, the verdict slips evidently did not reflect the dates. And
common practice to attach the indictments to the verdict slip. Now, I noticed in your brief you said there's no record of that. As I was reading Mr. Murphy's brief, I was going through the record looking for some indication of whether that occurred. But so apparently there is, even though it may be done, I mean, as far as I know, it was always done in cases that I sat on in the Superior Court, but then nobody makes a record that the indictment is being attached to the verdict slip. So that's something that maybe should be considered by the parties in the future to at least put it on the record. But
I believe that that is good practice. I think it is also good practice always to include the indictment. Now, I had thought of that after I confirmed that the verdict slips were indeed accurate. I made inquiry of the clerk of the Hampshire Superior Court of Judge Carey's practice, and the clerk informed our office that Judge Carey never attaches the verdict slips. So if he had, or if the record were incomplete in that respect, I would have sought to complete the record in order to save that part of the second count, the conviction. But I acknowledge Judge Carey's practice is not to include the verdict, the indictments along with the verdict slips. So we're deprived of that argument. I wish I had the ability to make that. So what are we left with? We're left with a jury returning 2 verdicts on rape cases, count 1 forcible rape, and count 2, once the aggravated portion is excised, with statutory rape. Now, is that a problem that both were jury return verdicts on both? No, because Judge Carey instructed the jury that the 2 acts must rest on separate and distinct actions. There was no risk that the jury would have determined that it was the same act that constitute the basis of the 2 indictments. At the beginning of his instructions, final instructions to the jury, Judge Carey emphasized that. At the end of his instructions to the jury, he emphasized that. And the jury is presumed to follow those, understand and follow those instructions. What the defendant is trying to do, I submit, is make time an element of rape of a child. It's only
I think he's trying to make time frames, not a specific date, clearly. But I mean, when you said that, I mean, could they have found that? Would they have necessarily had to find, under your argument, that one act occurred during the initial time period in the indictment and the other act occurred during the second period in the second indictment? In other words, could they have both happened in the first period, even though they weren't charged in that fashion?
The victim's testimony was general. He said he testified that the day after he turned 5 years old is when it began. It continued until after he was 6 years of age, and it was on a weekly basis. And he described different acts that occurred. Jury convicted for some, not for the others. Judge Carey emphasized, as I said, the rape convictions had to rest on distinct acts. It's possible, and this is the basis of my concession, it's possible the jury could have concluded that the act on count 2 occurred before the October 2008 date. That does not serve as a basis for reversal. It's still a crime. It's statutory rape. It only would serve as a basis if the time frame were an element of statutory rape. Now, the only time frame that's an element of statutory rape is that the victim has to be under the age of 16 at the time. But ordinarily, and I cite the appropriate case law in my brief, time or time frame is not an element of statutory rape. And again, this is not something that was objected to, so we'd have to look at prejudice, and there is no prejudice. The defendant's defense was he didn't do it. It didn't hinge on, well, I did it before or after a certain date. His testimony was, I didn't do it at all. And that was what he had told the police. He didn't do it at all. And any penetration would have been accidental, not deliberate.
I understand why you charged with the time frames to try to distinguish the aggravated rape. But having done that, so your position is that even though you charged the second one as a later date period, not a specific date, but a later time period, it doesn't matter if it occurred in any other time period whatsoever, as long as the jury considered that there was at least 2 separate and distinct counts in some time range that he was under the appropriate age.
Right. That's the only time frame that matters, is under the age of 16, unless the defendant can allege and show prejudice, because he would have a defense to one time range as opposed to another time range. And their cases are replete with the evidence not matching what had been presented to the grand jury, where it is a different day, a different week, a different month. Well, if it's not an element of the offense, it's not an element of the offense. And so, and in the absence of a showing of prejudice, which cannot be done here, the convictions stand. Now, I acknowledge there has to be a remand on count 2 for resentencing under statutory rape, because we could not show that the jury convicted the defendant after the October date on count 2. There's a risk that they didn't, and I acknowledge that. But there's no reason to reverse count 2, and there's certainly no reason to reverse count 1. There's nothing wrong with count 1's conviction. That stands. But I do acknowledge that count 2, the aggravated portion only, needs to be reversed and remanded to the Superior Court for resentencing. Unless there's further inquiry from the panel, I'm willing to rest on my brief.
Seeing no questions, thank you.
And we are back live and on the record.
Good morning, counsel. This is the third argument of the morning. This is case number 2020 P678, Commonwealth versus Dwight Clarke. Ms. Rogers?
Good morning, Your Honors. Mary Rogers. May it please the court.
All right, Ms. Rogers.
There were 2 convictions, one of possession of a firearm and the other of resisting arrest. As to the possession of the firearm, there were no fingerprints, no DNA. There's 2 cases, one in the appeals court and one in the SJC, where even though there was either fingerprints or DNA, that was still not sufficient. And there were other plus factors to those where they matched a description. A car was seen that was similar to the mother's car, actually in both cases. And it just, there was surveillance footage showing an assailant and his profile that was similar. So it's important that in Morris, they said, even though there was a reasonable inference, perhaps he was one of the intruders, it didn't reach the level of beyond a reasonable doubt. And that is extremely significant here, that it's not a preponderance of the evidence, clear and convincing, it's gotta be beyond a reasonable doubt. And with that in mind, turning to the factors here, there really weren't plus factors. There was no flight path. There was a significant amount of area that was covered where Mr. Clarke ran through backyards, having done nothing wrong, just chose not to be subjected to police interrogation or whatever may have come. That running shouldn't be given much weight in terms of what typically in the past was considered consciousness of guilt. Under Warren and Evelyn, newer cases, we realized that a young Black man in a city such as Boston or Springfield might run. And so we do need to keep that in mind. So it's a very small factor. Officer Turner said that he was clutching his waistband. Well, what happened was the car was stopped and immediately Mr. Clarke left the car as a passenger and ran. His back was to the police car behind them. Officer Turner and the other officer were still sitting in the car, and Mr. Clarke, as it was brought out on cross-examination, ran in the opposite direction. And to say that, you know, just touching your waistband equals having a gun there is pretty far out there. It's a real stretch. And to belie that, Officer Turner on cross-examination said that he did not radio broadcast that he thought he had a gun. He also didn't see the outline. He didn't see a gun. He didn't see anything in his hand or anything like that. So the gun was found in the backyard of 175 Bowden Street. Nobody, the trial attorney was very careful in her presentation that she made sure that she went through each officer that testified and made sure that they stated on the record that they did not see him in that backyard. And where the two responding officers picked up was halfway down the street, way far away from 175 Bowden Street. And so they weren't near. Admittedly, there was a shoe or a sneaker was referred to one or the other throughout the testimony that was adjacent to 175 Bowden Street. The officers didn't know what number it was. And then one of the officers, in my mind, kind of trickily referred to the distance in meters rather than feet. Obviously, I guess he could do that, but in this country with me, I don't know the difference between meters and feet. So I got out the handy calculator on Google and it turns out to be 49 to 66 feet. And so that was a significant distance. And then I looked very carefully at what the testimony was. It was kind of a mess as to what he said in terms of where they were. There was only one photograph of the gun, which looks like it's under a bush. And then there was one photograph of a shoe. And there's no photograph that shows where they were in relation to each other. So the only, the testimony about it was, so as you're coming to the yards, there's two houses that are adjacent to each other. They share a border via the driveway. There was a fence at the end of one driveway, which is at the corner of that fence. There was the shoe was located. And then on the other side of that yard was another fence, and that's where the gun was located. So you get from that, it was on the other side of the yard, far away, over a fence, under a bush. So going back to Morris, you know, that's not beyond a reasonable doubt. And you can contrast it with cases like Jefferson, where there was a gun on a front lawn. There'd been a high-speed chase. The gun was broken as though someone had thrown it and it was in pieces. The woman that lived there had been there for 20 years, never saw a gun in the neighborhood, never saw something like that on her front yard. So it's very indicative that it was probably very freshly put there, thrown there, and that was thrown. And so you can contrast a case like that where here there's no indication as to how long it was there. And then in contrast, this was a very high crime neighborhood. Excuse me. The two responding officers were very close by and they were sitting there and they were waiting for B&A assailants to come by in a car that were heading in that direction. So right in that neighborhood, we have all these police cars and activity. And again, the trial attorney brought out that it was a high crime neighborhood. And so in a high crime neighborhood, you have guns, you have stash guns where they put a gun nearby. That way nobody has it on their person. So there could have been drug activity going on. Somebody could have seen, they were all marked police cruisers, could have seen the police, could have decided to put something there. It could have been there for days or weeks in contrast to Jefferson. And another case you can contrast it to is, well, there's a few. And I really want to put you to my reply brief where I counted all of the assistant district attorney's cases, and she left out a lot of the plus factors. So you have a case like Patterson where the defendant took something from his waist, bent down, and they found a firearm in mulch and his hands had mulch on it. In another case, Diet, the clothes that the defendant had been wearing had his DNA on it. the firearm actually was in a flight path where they had been following, and there were two people they were following. One took off to the right, and that was the defendant, and to the right is where the gun was found. So it actually was on a flight path. There was no trail of items that the prosecutor points to. And also, as I pointed out in my reply brief, the broken fence was far from the firearm. It was halfway down the street. So do your honors have any question regarding that before I move on to the resisting arrest?
Oh,
No?
you can move on.
Okay, thank you very much. So with resisting arrest, it's the time when the arrest happens. It's not before that, it's not after, it's at the time when it happens. So
Well, what do you say is the time it happened here?
correct. That is when he was actually arrested at, he was running through backyards. And again, it was halfway down the street, and the officers started following him. Again, he hadn't done anything wrong, ran through a yard, and then the next yard between 151 and 131 Bedoin Street is when the fence got broken.
So your position is the chase does not constitute an arrest?
Yes, exactly, exactly. And there's plenty of case law on that, and it's in my brief. And so, yeah, and then supposedly they chose to chase him, and one of them chose to go over the fence. The other one went around the street. Both of them could have done that, but they didn't.
So is it your position, my understanding is for the purposes of search and seizure law, the moment of arrest is when the officer orders the defendant to stop, for example. Is it your position that the definition of arrest is different for resisting arrest than it is for search and seizure law?
No, I don't think so.
So if the police order a defendant to stop and he runs and they chase him and catch up to him, and the defendant is compliant at the moment when they put the handcuffs on him, you're saying that would not be resisting arrest?
Yes. What's the resistance? So, you know, I'm going back through the prosecutor's argument. To me, it was pretty obvious, you know, the arrest occurred when they put the handcuffs on him, when he stopped at the end of the street. He probably didn't hear them as he was going along. But it's when he got to the end of the street, absolutely, you know, unequivocally, the prosecutor doesn't claim otherwise, at that moment, he didn't resist. And so you can contrast this case with a case like Montoya, where somebody shot at police officers 3 times, took off, ran, went over a fence, and jumped into a canal that was 20 to 25 feet below. Now, that did put the officers at risk of substantial bodily injury. And in looking at the prosecutor's argument, she seemed to focus on substantial risk of bodily injury. So I just wanted to touch on that and point you to a case. It's a civil case, but it explains that bodily injury in the criminal context, substantial impairment of the physical condition, including any burn, fracture, any bone, subdermal hematoma, injury to any internal organ. And that site is 477 Mass at page 104. And it cites particular statutes, one involving children and other involving assault and battery on an elderly. So it's not a stub toe, it's not a skin knee, it's something substantial. It has to be something more than I scratch my elbow. And then, you know, on the other hand, there's a case more similar to this case, Quintos Q, where the defendant was a passenger in a car. It was a high-speed chase. Defendant got out and ran. He jumped over fences. He was cornered. He was arrested without incident, not a resisting arrest case. So I I was kind of shocked this wasn't granted at trial, but I think, you know, just running from the police, it can be clarified even more so perhaps in this case, that when you look at what I wrote in my brief, I certainly hope that the court will find that resisting arrest was not in this case, and just running from the police isn't resisting arrest. It's about what could happen to the officers, you know, and if they choose to run after him, fine. My client didn't run into a canal or something like that. A high-speed chase, for instance, you know, going the wrong way down a one-way street when it's a busy area, those things would be resisting arrest. But here, running in a backyard, which happens, is not resisting arrest.
Counselor, before your time runs out, I have a question about the armed career criminal issue. And it's this: if you're right that this wasn't a proper armed career criminal predicate, then why wouldn't we have to remand for the imposition of the 10D enhancement?
Because of Commonwealth versus Richardson, that it was up to, okay.
Under Richardson, if a judge has two valid enhancements, the judge chooses one. But if there's only one valid enhancement, and that's the 10D enhancement, then wouldn't the judge have to impose that and actually give your client a higher sentence?
No, at the time of the sentencing, that wasn't chosen. And actually in my particular case, it can't happen because my client has finished his sentence. But no, I did look at that very carefully before I raised this issue. And no, the DA had the right to choose which one they wanted to proceed under. And so that one was dismissed, I believe was what the ruling was. So what, you know, you can't revive it and start indicting and trying it all over again. That would violate double jeopardy, and double jeopardy applies to sentencing as well.
He's already found him guilty of the second offense in the armed career criminal. He just chose, so the guilty's never gone away. The case is still guilty on his record in the sense, but it was the enhancement penalty was chosen as the armed career criminal, which was the lesser penalty.
Let me just let me just double check in my brief, because I believe I put it in a footnote that it was dismissed. You can't have two guilties because of Richardson. You just can't. But let me see if I can quickly find it.
Well, what would prevent the judge from vacating a dismissal at that point?
The court dismissed the enhancement. Footnote 3 in my brief, they found him guilty of second enhancement under 10D, but Richardson had to be dismissed. So it would be double jeopardy to try to revive that. Can't do that. In this case,
the dismissal's not a not guilty.
But that would be before a trial. You know, he was tried in the context of this whole case. It was, you know,
your position is it would be double jeopardy.
Yeah, exactly. I had to think that through. Exactly. It would be double jeopardy.
All right. I notice your time is up. Thank you, Attorney Rogers. Attorney Kohler.
Thank you. Good morning. May it please the court. Carrie Kohler for the Commonwealth. The Commonwealth's theory at trial, and in the light most favorable to it here, was that Mr. Clark was a passenger in a car that was lawfully stopped. There was a civil motor vehicle infraction, I recall. And as the officers were approaching the vehicle, they saw Mr. Clark moving around in the compartment, saw him moving towards the storage area in the middle, and reaching towards his waistband as he ultimately ran away from the scene of the motor vehicle stop. Other officers responded to those stopping officers to pursue the defendant. And I'll acknowledge the record isn't as clear as it could be about where all the roads were and where the distances were. However, it was one street that was referred to Bedoin, and the numbers of the houses are relatively close in numerical order to one another. So I think it's a reasonable inference they were close to one another.
those response.
You agree under Warren that he had a right to leave that scene?
I don't think so, but I don't think it matters in this particular case. I don't think he was free necessarily to just run away, but I think it doesn't matter here because even if he was, let's say he was free to run and free to run down the street, he wasn't free to enter other people's backyards and cause property damage. And continue to run away from the police when they said, stop, you're under arrest. And again, it doesn't matter if there was a crime occurring in front of them. The moment they tell him you're under arrest, stop, he has to stop. And he didn't. And the testimony was pretty consistent and clear from both officers. I believe it was Cicero and Aviles who said, I believe it was Cicero was calling out that he was under arrest and to stop, and he wasn't. And I think some of the defendant's arguments about whether he could see them and whether he heard them are not in the light most favorable to the Commonwealth, and I don't think they're properly considered by this court. I think there's evidence in the record he should have heard them, he heard them, and he continued to run anyway. And officers were joining in the chase. So I think it would be reasonable to infer from all of the evidence that Mr. Clarke knew that he was under arrest. So the Commonwealth's position is that even if he was free to go, he couldn't continue to run, and that the chase itself presented the serious bodily injury that the law requires. So with respect to that, on the facts, there's sufficient evidence that he was resisting arrest. With respect to the possession of the firearm, the Commonwealth would, again, the evidence is really all about that chase. And there was testimony about how at the conclusion of the chase, after the defendant's in control or under officers' control, they go back and retrace the flight path. And I think it's reasonable to infer from all of the evidence that where the defendant's running are items recovered that can reasonably be connected with him. It's 12:20 at night. There is no evidence that there was anybody else around except for Mr. Clarke and the police officers and the driver at the scene of that motor vehicle stop. So the area that he's running away from has his shoe, it has a broken fence that the officers watch him break, and it has a firearm that is recovered by the officers. So I think in the light most favorable to the Commonwealth, the Commonwealth carried its burden that the defendant possessed that gun. And while I'll acknowledge that there's certainly the majority of the cases with the so-called plus factors have more evidence, and more evidence is always better, that doesn't mean that this case is insufficient. It's not. The defendant's behavior in the car, his flight from the police, and the various items that are collected by the police during their investigation all support that the defendant had actual control of that firearm, that he had it in the car, that he secured it on his person, and that he ran away with it because he wasn't allowed to have it because he didn't have a license. So if the court has any questions about sufficiency.
Yes, they do. I mean, so Officer Turner testifies that we retraced the footpath from where that foot chase took place to our car. And that's where we started searching the area. But what does that mean, from where the foot chase took place to our car? I thought his car was where the chase started.
Well, I think what Officer Turner was trying to artfully say, since he wasn't part of the chase, was he was distinguishing between those two areas. There's his car and his part, and then there's the officers that are chasing, and they don't. I guess they technically don't start at the same place. He has a point. The foot chase doesn't start from the passenger door where the officers are approaching under the spotlight with the lights going. I believe it was Turner and Officer Ellison who were the stop officers. and neither one of them were engaged in the foot chase. Cicero and Aviles come onto the scene and sort of join the investigation and begin the chase. So there isn't that continuity of the single officer conducting the stop, pursuing the individual, and concluding with their detention and arrest.
But that's the only testimony about the path. How do we have any confidence that this gun was found in the flight path?
Well, Your Honor, I would say that testimony is sufficient, and the confidence it's a credibility determination, and that's resolved in the
based on that testimony, the area where the gun was found was theoretically between where Turner was, where the car was stopped, and where the other officers began their chase. So that was that area before the chase began, but after Turner saw him began running. Does that make sense?
I'm sorry, I think you cut out at the beginning.
Turner saw him begin running, and the other officers picked up a chase down the way.
Mm-hmm.
So the gun was found in that gap between where they began chasing him and where Turner first saw him begin running. Is that?
I don't think that's entirely clear. I understand what the court's saying. I don't think that's entirely clear. I think you have to take everything all together, which is Turner's testimony with the physical evidence that the various officers were describing. I don't think there's a clear description of the chase from any single officer.
But we're also stuck with, even taking in the light most favorable to the Commonwealth, that nobody can put him in that backyard.
And I agree with that. And I don't think it's necessary here because I think that the evidence is sufficient to connect him from that point of motor vehicle stop at the car to the conclusion of the arrest. And from the beginning to the end, it's not necessary that he's directly observed because we have the additional, I guess you can call it information from the items that are collected in the backyard that connect him uniquely to that distance. It's not just there's a firearm and it was discarded. His shoe's also there. And he is at least observed traveling and then being pursued by the other two officers. So I think all of those things together create the necessary and proper circumstantial evidence to demonstrate that he was in possession of the firearm that was collected in one of the Bedoin backyards. I think that's fair to state here.
And it's clear the jury was only instructed that they had to find that he possessed it in the car.
Yes, I agree with that, Your Honor. That's correct.
All right.
Would the court like me to address the due process claims at this point? Thank you. The Commonwealth's position is that Baez is the controlling case here, even though the SJC didn't address the due process violation for the void and vagueness argument with respect to juvenile adjudications as a predicate. The Commonwealth's position is that the defendant's argument really doesn't differentiate too much in substance from what was before the court in Baez. The defendant raises the challenge that the language of 10G of ACCA doesn't put the defendant on notice of what his prescribed conduct is. And there's two, I think, strong arguments against that. The first is juvenile adjudication is specifically imported into ACCA. It's specifically and explicitly addressed by the definition of violent crime. And the other argument about notice, which I think is sort of the defendant was a juvenile at some point and during the predicate, and he couldn't understand what the conduct prescribed meant he couldn't do. I think that fails as well because the statute, as construed against him, is clear about what's prescribed. You can't have a firearm without a license in the Commonwealth, right? And you can't commit an assault with a firearm against another person.
I read the notice as being put on notice that there was a potential for an enhanced penalty in the future.
I think even if that's the case, and it could be, I think the court could analyze it either way. I think that is the same here. It's a consequence upon the defendant based on his criminal conduct. It's not unusual, not unreasonable that there are enhanced penalties. The more involved a subject becomes in the criminal justice system. And there's no difference, I'd submit, between juvenile involvement and adult involvement, depending on what kind of statute you're under. And there are, and I forget the name of it, but I know my sister cited it extensively in her brief. There are means to punish a juvenile for subsequent offenses while he or she is still a juvenile. And that moving into the adult arena, it's not unreasonable to rely on juvenile adjudications to serve as a basis for enhancing penalties. And in our particular circumstances, the legislature has prescribed conduct that occurs in one's juvenile years as properly serving as a predicate offense when you are charged with certain offenses in adulthood. And here that's exactly what happened. And the defendant in particular has faced graduated penalties, unfortunately, his entire life. He's come before the juvenile courts, the district court, and the superior court. And so I think in this particular case, notice is not an issue. And in general, it's not an issue because of how the statute is written and the legislative intent is very clear. And I don't, very briefly, I don't see how Baez is holding that a delinquency can be a predicate offense for a 10G enhancement doesn't carry forward for a youthful offender indictment, where the youthful offender indictment is arguably less protective of a juvenile than a delinquency complaint.
Just as a point of clarification, it was unclear to me what happened on the youthful offender charge.
He received a suspended sentence, violated that probationary period while this case was pending, this case actually, and that sentence was imposed. And it essentially functioned as like an 18-month house sentence concurrent. So he has served a sentence for that.
Did he go to trial on that offense, or was he?
No, he pled that case out.
Okay.
So, thank you.
All right, seeing no other.
Home reconstruction. Your Honors, this is a case that started in the land court, was brought by Mr. and Mrs. Sullivan seeking a judgment that they were the owners of a certain strip of land known as Templeton Way. And Templeton Way is a small paved area that connects and goes in front of some real estate that is owned by Mr. and Mrs. Sullivan. Home reconstruction is essentially advancing three arguments with respect to the appeal.
Could I just stop you for 1 second? I'm not sure if you have the YouTube on.
I do not.
Okay, I'm getting a little feedback. But go ahead. It's
Okay.
not.
I don't, and I turned off the speaker that I have on my computer as well, so that it wouldn't do anything. So I apologize. So the first argument is that while this is a private way, that it was accepted by the city of Boston as a private way for public use. And I understand that Mr. and Mrs. Sullivan in their brief have raised an issue that Home Reconstruction is raising an argument in its appeal that it did not raise at the trial court and should be precluded from raising it. It is Home Reconstruction's opinion that it is not changing the argument that it raised in the land court, which is that it is a private way that was accepted by the city of Boston for public use. And the arguments that are advanced in its brief are, what does that mean? And should the trial court judge have allowed in testimony from representatives of the city of Boston as to what does that mean? And what do the street indexes that show it as a private way open for public use? And what is that?
What exactly
what does that mean?
was it that you are saying that the city engineer should have been allowed to testify to? And is it a opinion about the law? And would that be admissible?
I don't think that it's, my position is that it is not an opinion about the law. It's an opinion about how they interpret the city street index books and what the determinations that are in the street index books mean. They have certain definitions, they have certain qualifications that are in the street index books. And it is true that Mr. O'Callahan, who was the Home Reconstruction's witness, did testify with respect to that, but he certainly isn't someone who was an employee of the city of Boston who could testify as to the fact that, for instance, the city of Boston doesn't put streetlights on private ways unless they are accepted by the city for public use, which was.
What does that mean, though? And I think Mr. Duffy brings out in his brief, like, what is there's, in other words, there's private ways and public ways. A private way accepted for public use. There was no case. I mean, he suggests you've cited no case that says it's a public way. In other words, because they use like allowed or accepted for public use, are you suggesting it is a public way? Is that your argument, that it in fact has become a public way?
Well, I think what the argument is, and I think what would have come out if the testimony had been allowed is that because the city treats it as a public way, it's open to access to the public. And so I think that's really what the issue is you can, at least as I understand in my reading of the city street index books, the way that they treat it is it can be a private way, but they allow the public to have access to it. And if they allow the public to have access to it, then there are certain things that they undertake, which would be, for instance, the streetlights. So it would be our position that if that is what happened here, and certainly the street index books make that clear, but since the judge didn't allow any testimony of the employees to explain any of it, we're left with either going back and having that testimony come in or looking at just what the street books say. And the street books say,
assume that the public go on Templeton Way. I mean, there's no gates blocking it, so that seems right. What's the effect of that?
Well, I think that the effect of it is that the question really is that if it's treated as a private way that's been accepted for public use, then the argument is can you adversely possess something that's open to the public?
I mean, do you agree that unless it actually becomes a public way through prescription or through the statutory scheme, then it can be adversely possessed?
I'm sorry, I don't think.
The only way it would be immune from adverse possession is if it had become a public way, a full-on public way through prescription.
Well, except that I think that the argument can be made that if they were to adversely possess it, they can't block it or do anything with it. So they really don't have, and they don't really adversely possess it if it's open to the public, because that would mean that they would have an exclusive right to close it off, which they couldn't do if it's open to the public.
Why would that be the case unless the public had gained prescriptive rights to the way?
Well, I think that if the city has accepted it as open to the public, then I think that the argument can be made that's similar to prescriptive rights of access as a public way.
Okay, so you tell me what in case law or statutes say that if the city has accepted something as a private way for public use, it can't be adversely possessed.
I think that well, it's a question of how you interpret the statute that says that a public way can't be adversely possessed. I would make the argument that if it's a private way that's accepted for public use, then that's the same as it being considered a public way for it not being subject to adverse possession.
Okay, where did you make that argument below?
The argument that we made below was that it was a public way accepted, a private way accepted for public use.
No, the argument below was that through prescription, it had become a public way. That's in your memo afterwards. Is there any place where you made an argument that even if it's not a public way through prescription, that Chapter 86, Section 3 means it can't be adversely possessed, even if it's still a private way?
I did believe that the trial counsel made that argument below. I was not trial counsel, but I do believe that he had made that argument below in his submissions to the court.
Okay.
The second argument that home reconstruction advances is that that the Sullivans have not met their burden with respect to adverse possession. The primary issue, or the primary position in this case is that there was this fence that was erected by the predecessor entitled to home construction, and that the erection of that fence and the fact that the fence had been up for a number of years is the thrust of the case as to why the Sullivans have obtained rights through adverse possession. And the trial court relied on primarily two cases. One was Casey versus LaCourte, and the other one was the LaSalle College case. And in my brief, I do distinguish the fact that in this case, other than in Casey, the court said that the fence, that it wasn't just the fence, that the fence alone isn't sufficient to make out a case for adverse possession. And the testimony of Mr. O'Callaghan at the trial court was that the purpose of the fence was to keep trespassers out of the property that was owned by Home Reconstruction's predecessor entitled. It was a commercial property, and there were trespassers that were coming in through Templeton Way. And so it's our position that you can't look at just the fence as being the determining factor. And other than the fence, the only other testimony that Mr. Sullivan put forward was that he had never seen anyone else use the way. But in the testimony, it was also brought out that Mr. Sullivan never has and does not live there, that he owns other properties and is, while he says there every day, he did not distinguish that he was there 24 hours every day, or that he was there.
So are you asking us to hold that an owner can't adversely possess land unless they live on the location adjacent to the adversely possessed, the parcel at issue?
No, not at all. Not at all. That's not what I'm saying. What I'm saying is that if you look at what the testimony was, there was testimony as to what the purpose of the fence was, how long the fence had been there, what the condition of the fence was, which is obviously one element of the claim of adverse possession, is that this fence blocked it off. The other evidence, the only other evidence that there was Mr. Sullivan's testimony that he never saw anyone use the way, and that he was the only one that used it.
And that he maintained it.
Yes, he did. He said that he, I believe he shoveled snow. He testified that he shoveled snow. He also testified that he did not pay taxes on the way. that it's not included in the property that is included in his deed for tax purposes. And I think he said that tenants of his used the way to exit the front doors of their buildings. But that was the only testimony as to the other uses of the way and whether or not anyone else ever used the way.
Was the fence there? What other use is there of Templeton Way other than to access 1 to 9 Templeton Way?
It's my understanding that it goes out to Monsignor Leiden Way on one end.
Right. But it doesn't go anywhere but to 1 to 9 Templeton Way once the fence is there. So what possible other use is there of Templeton Way once the fence is there other than to access 1 to 9 Templeton Way?
Unless someone were to go around the fence and use it to get to Monsignor Leiden Way. I don't know what other use there could be. But what I'm saying is that looking at what the testimony was, is that the only other testimony is that he never saw anyone else use it. There was no testimony that no one else could use it. It was that he never saw anyone else use it.
But if a situation where nobody else would ever have any reason to use it, why doesn't that have some weight?
It may very well, but I don't think it's not my understanding that that's what the testimony was, because someone else could have used it to access Templeton Way.
Templeton Way, the only place it goes is to the townhouses.
And then out to Monsignor Leiden Way.
It connects from you go from Leiden Way and you get into the townhouses on Templeton Way from Leiden Way. There's nothing else to use that for once the fence is there.
Except for the property that Home Reconstruction owns on the other side.
But you can't get to that because there's a fence.
Well, except that I think
for years.
Except that Mr. O'Callahan's testimony is that there were holes in the fence where people could get through.
And then he said, nobody could get across the boundary from 12 Mount Street to Templeton Way through the fence, correct? That's correct. So holes or no holes, he said you still couldn't get to your client's property. So what use is there for Templeton Way with that fence there?
Based on what the testimony was, the only testimony is that the use was between getting from Templeton Way to Monsignor Leiden Way.
Are you arguing that the possibility that a member of the public would turn onto Templeton Way from Monsignor Leiden Way because they're lost or they're making a 3-point turn, that possibility alone would be enough to prevent the Sullivans from having exclusive possession adversely?
I don't know whether, I don't think, in all honesty, I don't think without more than that alone could be a reason. I think that the question is whether there was enough testimony other than the fence to show that they had adversely possessed the property. And I think that's what my argument is that the only other testimony, well, there was Mr. O'Callahan's testimony, but Mr. Sullivan's only other testimony is that he never saw anyone use it. And so,
according to Defense Exhibit 2, there is a driveway from the new property to Mallet Street. So what's the problem?
As I understand, the issue is that the home reconstruction owner wanted to be able to use the numbering of Templeton Way. And so the only way to be able to use the numbering of Templeton Way would be to be able to have access onto Templeton Way, and that's the way the building permit was issued by the city of Boston. It's my understanding that it issued as with street numbers or house numbers on Templeton Way.
So the prejudice to your client is he'll have to renumber the property?
Well, not only that, but that's how the building permit issued as well. The building permit issued with properties listed on Templeton Way.
And what's the effect of that?
I'm not 100% sure as to what the effect of that is and whether he would be required to amend the building permit. But it's my understanding that the building permit issued with the street numbers as house numbers as Templeton Way.
It doesn't deny him access to that property, correct?
No, except that, well, it's my understanding that the way that it's set up, the people could not come out of their houses onto Templeton Way. if Templeton Way is under the exclusive ownership of the Sullivans. They could only exit the properties onto Mallet Street, not onto Templeton Way, because they wouldn't have any right to. So it would affect their ability to come out a door onto Templeton Way, because based on this decision, they have no ownership rights in it or no right to use it, even as a public way.
And I see their time has expired. Attorney Duffy?
Muted.
You're on mute.
Thank you. Good morning, Your Honors. I represent Sullivans. This is a case essentially where the trial court got everything right on the substantive legal questions of adverse possession, abandonment, and latches, and also correctly precluded the admission of irrelevant evidence with no tendency to establish any material issue in this case. In fact, as Your Honors have alluded to, posture in which HR LLC has presented its argument on appeal as to the materiality of this precluded evidence contradicts the presentation of the defendant's case at trial. Not only had HR LLC stipulated to the fact that Templeton Way is a private way, but there was no presentation whatsoever during the entirety of the case that there was any support under the statute or in any conduct to find otherwise. And so our position is that eviscerates the chief argument that defendants are making now on appeal, that Templeton Way couldn't have been adversely possessed by the Sullivans. There's no authority that we're aware of that prevents that eventuality, provided the other elements of adverse possession can be met, and they were met here.
Well, below they argued that it had become a public way through prescription, and therefore it couldn't be adversely possessed.
That's
and considering that there's nothing blocking the public from going onto Templeton Way, why isn't that a valid argument?
It's not a valid argument, Your Honor, because there was no evidence presented to establish prescription in favor of the public in the case below. In order to do so, the HR LLC would have had to demonstrate actual public use, general, uninterrupted, and continued for the prescriptive period. There was no evidence of the length of time or there was no evidence of any use actually by any member of the public. The only testimony concerning use of Templeton Way came through Mr. Sullivan, and his testimony was that he has owned the property since 1985, that he's on the property nearly every day, and that in the entirety of his ownership, he's only ever seen himself and his tenants use Templeton Way. There's no testimony to support that any member of the public has ever used it for any purpose whatsoever. In fact, the only evidence that suggested any sort of tie to any public connection was testimony about the existence of utility poles, 2 utility poles that are alongside Templeton Way. There's no evidence that was presented in the case that they are actually on Templeton Way as opposed to being on the boundary or on the adjacent property. No survey evidence, nothing to that extent. There was no evidence concerning any members of the public using Templeton Way for travel by foot or vehicle, and the testimony was undisputed that Templeton Way dead ends behind the plaintiff's property, and that there would be no purpose for the public to travel that way as it doesn't lead anywhere. It doesn't lead to any other ways, parks, or amenities. And the fact of the matter is, no one could go around that fence. The property, the entire property that the plaintiffs own is surrounded on 3 sides by fencing. The only way in and out is to enter through Templeton Way, and there's no place to go to once entering there. You can go in, you can come back out. So there really can't be any serious debate that HR LLC failed to meet any burden to demonstrate Templeton Way had become a public way by prescription. There was no error in the trial court's determination that Templeton Way is a private way. As to the case for adverse possession by the plaintiffs in this case, this is really a consideration of the extinguishment of an easement right by prescription. which requires adverse use inconsistent with the continuance of the easement, or a use which would be privileged if and only if the easement did not exist, and such use is adverse and meets the other prescriptive elements. The trial evidence more than adequately supported the trial court's findings on this issue. The trial court found that Templeton Way is a 12.58 foot wide way abutted for its entire length by a fence, and to the west by a 10-foot tall stockade fence on the property line between Templeton Way and the 12 Mallet Street property. The front doors on the Sullivan's units buildings all open onto Templeton Way, which is narrow. Mr. Sullivan testified that only he and his tenants use it for access to the buildings, primarily on foot, sometimes by vehicle for moving furniture in. He testified that he's at the property almost every day. He's never seen anyone other than tenants and himself using the way. HR LLC offered no testimony whatsoever to any fact otherwise. And the evidence was also undisputed that the Sullivans exclusively maintain the way. HR LLC has never done any maintenance work or paid for any maintenance work of the way. And the trial court also correctly found that the fence between the way and HR LLC's lot, which has stood on that boundary continuously since at least 1985, prevented HR LLC and its predecessors from making any use of Templeton Way for passage by any means. And there, as discussed previously, there is no basis for a conclusion that Templeton Way somehow became a public way that would have the effect of frustrating this case for prescription. Similarly, the court was correct in its determinations regarding abandonment of the defendant's rights in Templeton Way. The Massachusetts courts follow the restatement of property of servitudes concerning modification or extinguishment by abandonment. And that section reads that a servitude benefit is extinguished by abandonment when the beneficiary relinquishes the right created by a servitude. There must be some showing of intent to abandon an easement by acts that are inconsistent with its continued existence. And those facts are present in this case. The requisite intent can be ascertained from the circumstances and conduct of the parties. In this case, we have a predecessor in title who, it's undisputed, erected a 10-foot tall stockade fence on that boundary line, which contains no gates, no openings whatsoever. There are no holes in that fence that would permit a person, even on foot, to traverse that boundary. And while that may have been the case that Mr. O'Callahan suggested a prior fence at some previous point in time had gates or openings, the fact is undisputed that for approximately 35 years, there was a solid fence on that boundary erected by the property owner at 12 Mallet Street that prevented any access across either way, leaving the Mallet Street property to access Templeton Way or entering the Mallet Street property from Templeton Way. This is a case that is very similar to the authorities that the trial court relied on in reaching its conclusion. And the trial court cited this court's decision in Casey versus LaCourte family. In that case, the defendant owned a property abutting away. The predecessor in title, which was the Archdiocese of Boston, owned that property. And sometime during the Archdiocese ownership, it installed an iron fence with no openings on that boundary. And at some point thereafter, the Archdiocese replaced that fence with an 8 to 10 foot chain link fence topped with barbed wire. The plaintiff in Casey parked cars on the way and paid to pave and clear snow from storms. The Archdiocese never contributed to any maintenance. And in upholding the land court's determination in that case, the court stated that a conclusion that the Archdiocese abandoned its rights was compelled based on the prolonged lack of use, the maintenance of successive fences, the blocking of the way by parking of cars and use by the plaintiff, the Archdiocese failure to object to the plaintiff's use, exclusive use in essence, and the Archdiocese lack of any contribution to maintaining the way. I would suggest that these factors, while they're not identical in every particular, they are identical in every meaningful way to the case that was presented here with the same or similar factors all, I would suggest to this court, compelling the same conclusion. And that was obviously what the land court felt as well, and I submit correctly. This court reached a similar result in another case, LaSalle College. In that case, the court reasoned that the owner of the Servian estate proved abandonment with evidence of non-use, acquiescence in the use of the way by others, and by establishing the equivalent of an intentional surrender of the right of use in the way by the defendant's constructing a fence, separating his property from the way, which remained in place at the time of the appeals court's decision. And that's the same set of facts that would apply here as well. I would suggest that there was no evidence that would have undercut any of the court's findings concerning abandonment in this case. The evidence, which was largely uncontroverted at trial, more than sufficiently established abandonment, and there was no error and no basis to reverse that determination. I would just touch briefly on the defense of latches. I would submit to the court that was properly determined in the land court that the defendant had failed to establish their defense, and that judgment should also be upheld on appeal. Latches is an equitable defense and is must be submitted on the basis that the plaintiff was wrongfully not taking appropriate action and availing itself of its rights. So I would submit there's no evidence to support that determination in this case. In fact, both parties testified that nobody on behalf of HR LLC informed the Sullivans about HR LLC's plans to purchase the property or to develop it with any additional building. HR LLC commenced its redevelopment only after obtaining a building permit. There was no need for zoning relief, and therefore there was no public hearing or other notice requirement that had to be met that would have brought the Sullivans' attention to what was planned or what was going on the property at 12 Mallet Street. And for approximately 35 years or longer, a 10-foot tall stockade fence did all the talking for HR LLC, and the message it was delivering was, we can't access Templeton Way. We have no way to do it, and therefore we clearly have no intention to do it. As Mr. Sullivan testified, for the first time that he became aware of any plans by HR LLC to try to make use of Templeton Way was when he observed construction of foundations on the 12 Mallet Street property. That prompted him to have a discussion with the representative, the construction person who was working on site at that point in time. And that person indicated that there was an intention for either foot traffic or vehicle traffic to come into 12 Mallet Street over Templeton Way. Mr. Sullivan testified that he said at that point in time, in words or effect, that we'll see about that. Shortly thereafter, Mr. Sullivan's counsel delivered a no trespass letter to HR LLC, and then this action was filed about a year later. There's no evidence in the record to establish that HR LLC did anything between the time of that conversation that Mr. Sullivan had with the construction person and when this case was filed to make any material change of its position or reliance on anything that Mr. Sullivan had done or not done. There's no evidence that HR LLC suffered any prejudice during that period of time or that it suffers any prejudice now. In fact, based on the evidence in the case, we submit the trial court properly found that the Sullivans acted reasonably and diligently in bringing this action after learning the facts that were necessary to put the Sullivans on notice that there was a claim by HR LLC to a right to use that property. In addition, we would submit that HR LLC has not come forward innocently with clean hands in this defense. The fence was constructed on HR LLC's property a long time ago by a predecessor in title. Mr. O'Callahan, who was the witness for HR LLC, testified that he was aware of that 10-foot tall fence when HR LLC purchased the property. HR LLC did no research, took no action to determine what rights it had or what obstruction to its intended plans that fence might present. Did not inquire as to the length of time it was there or what the circumstances was. And HR LLC claims that it had to submit it had frontage on Templeton Way in order to get street numbering. The evidence demonstrates, however, that HR LLC knew there was not any existing practical or effective access to Templeton Way to support its claim of any usable frontage there. Nothing in the record establishes that HRLC made the presence of the fence or lack of practical access apparent to the city in any of its requests for building permits or building numbering, and whether it made a representation concerning that frontage, express or implied, it was made with knowledge that there was a fence there. We submit that HRLC had no reasonable expectation or claim of rights to use Templeton Way. And ultimately, for those reasons, in addition to the failure to prove that there was notice by the Sullivans or any lag in action, HRLC ultimately failed to identify any basis for its laches defense. And we submit that that was also properly decided by the trial court.
All right, time having expired.
We are back live and on the record.
Right. Good morning. This is the fifth case of the day. It is docket number 2020P0082, Department of Children and Families and Another versus Mother and Another. I just caution the parties that there is impounded material here. I know the mother was present, but because of some technology issues, we were not able to bring her live to the Zoom hearing. With that said, we'll begin the argument. Be back now.
Thank you. Good morning, Your Honors. My name is Attorney Bagnall. I represent the mother in this case. And respectfully, I'm here to request that this court reverse the decision terminating her parental rights. This is a case that involves a mentally challenged mother who, at the time of trial, the judge recognized had not been afforded the same opportunities that other parents without disability are afforded by the department. This is a case that's 6.5 years old, but 3.5 years into the case, after the first trial in March of 2017, the judge made findings, specific findings, that the department virtually had done nothing by way of efforts, reasonable efforts, in helping mother achieve or demonstrate her ability to parent her daughter. This is a case where from the moment that the child was born, the department came in and took the child from mother, and the facts support the contention that the department throughout this case never had an intention of returning that child to mother. Child was placed in a pre-adoptive home just 8 weeks following, excuse me, sorry about that, just 8 weeks following the removal, her birth. Child was placed in the pre-adoptive home. Just 6 months following the removal of the child, the department changed the goal to adoption. Following that change of goal to adoption in February of 2015, the department for 3 years essentially did nothing to help this mother.
The judge held that the parent aid for 6 months was reasonable efforts on the part of DCF. Why isn't that reasonable efforts?
I would argue that the parent aid was too little and too late to constitute reasonable efforts. The parent aid was not appointed. So to continue in answering your question, there was a parent aid appointed to mother. That service was provided in June of 2017, 4 years after the child had been taken from mom. The parent aid worked with mother for approximately 6 months. There's scant evidence and findings regarding the parent aid. I believe there's only two findings, finding 287 and 288 made by the judge, that there was little evidence offered as to what the parent aid did with mother. The findings regarding the parent aid was that the parent aid found that mother often became frustrated with topics such as housing, the department's lack of efforts, services with her, and sometimes during their sessions focused more on that than, quote, what the task that the parent aid was trying to demonstrate or teach mother. Those tasks were never identified on the record. They never were explained to the court. And that essentially is the only service that the department offered mother, other than the visits that took place 2 hours weekly from March of 2017 through December of 2018. In addition to the lack of services that the department provided mother, also the treatment of mother, the differential treatment of mother by the department. Mother contends that the facts and findings of the judge taken together are not detailed enough to substantiate the finding that mom's cognitive limitations somehow render her unfit to parent her daughter. There is ample evidence on the record that mother was able to parent her daughter, given the limited circumstances in which the department allowed her to demonstrate that. The evidence against mother and in support of the court's termination of her parental rights is scant. Just a couple of examples: mother arguing with the department about not putting a helmet on the child when she was on a tricycle, mother taking too much time during a visit to put together a stroller and not paying enough attention to the child. And again, another visit where mother, at the request of the child, took too long to put together a video game. The evidence on the record and concluded by the court was that mom did make improvements from the first trial to the conclusion of the second trial. And the trial court puts great emphasis on even the fact that she made those improvements, but the fact that she was never given an opportunity to demonstrate her ability by the department. The court was not able to say with certainty that mother would be able to parent her daughter. And so the two issues were intertwined, is what counsel is arguing. Never was a visitation.
Are you arguing that unless a parent has unsupervised visitation, DCF can never show that it's made reasonable efforts at reunification?
I'm arguing that the department didn't go to unsupervised visits in this case based on nebulous concerns. They never established why they didn't go to supervised visits, other than just saying they didn't feel comfortable. And they never made efforts to get mother to unsupervised visits. You know, at the time, mother was living in an apartment in a program, one that she on her own initiative sought out. And it was an apartment and program that mother could have been reunified with child. There was supervision provided to mother through this program. And mother was living with a roommate. Mother was caring for the roommate's child. It's inexplicable that the department didn't go to unsupervised visits in this case. But again, mother's arguing from the time the child was born, the department never had any intentions of returning this child to mother's care. And the rationale for the department was that mother was cognitively limited and unable to care for her child. But there's great contradictory evidence to that. Mother was able to find housing. Mother was able to provide transportation for herself. Mother, at the time of child's birth, had ample supplies for child. Mother had a job, 2 jobs during the course of this case. And mother, at the time of the second trial, was enrolled in college, seeking out an associate's degree. Evidence points to the fact, ample evidence points to the fact that had mother been given the chance, she would have been able to demonstrate that she could have cared for this child.
Well, couldn't the judge base her opinion on the bonding evaluation though?
Mother argues that, again, 6.5 years this case, Your Honor, has been going on. The bonding evaluation, Mr. Barry, I believe is his name, occurred 5.5 years after the child was taken from mother and placed into the pre-adoptive home. Well, the bonding expert certainly concluded that it would be detrimental to the child to remove her from the pre-adoptive home. The record is absent of any type of effort that could have been made to alleviate those concerns. There was no effort made to alleviate those concerns regarding the bonding issue with the pre-adoptive. And in fact, the court found that there was a significant relationship between mother and her daughter, significant enough to warrant the post-termination visitation order. I would point the court's, I'd point your attention to the fact that in April of 2018, the child at a doctor's appointment went up to mother and said, "Hi, mommy." She knew as late as April of 2018, I have to apologize, that mother was her mother, her biological mother. But I would argue that in accordance with adoption of Catherine, that the department and the professionals involved in this case had an obligation to address how possibly they could have eliminated the concerns brought up by the bonding expert if the child were transitioned back to mother. And that did not occur in this case. Again, no efforts by the department in this case to alleviate those concerns. And I would argue great effort on the part of the department to make it so that this child, an expert would find that there would be some detrimental impact to the child should she be removed from the pre-adoptive home. But that in and of itself, I'd argue, is not enough to warrant termination of mother's parental rights. I would conclude by respectfully asking this court to look at the whole record, which in its entirety, 6.5 years, the findings of this particular trial judge are particularly troublesome. Repeatedly throughout her entire findings, first after the first trial and after the second trial, the judge acknowledges that the department did nothing other than the parent aid for 6 months. And respectfully, I'd ask this court to reverse the lower court's decision and to remand this case and on both the issues of reasonable efforts and the fact that given the issue of lack of reasonable effort, the trial court could not make the specific findings required to permanently sever mother and daughter's relationship. And
do we know anything from the record about why the parent aid use ended when it did and why there wasn't another parent aid?
No, the record is silent to that. Mother did acknowledge at the second trial that she benefited from that service and that she could use that service again. But the record is silent as to why it was terminated or ended and only given to Mother for such a finite period of time, which was approximately 6 months. If there's no more questions, I'll be happy to rest on my brief.
All right, thank you, counsel.
Thank you.
Are we going with Attorney Frizzoli?
Yes, Your Honor.
Okay, go right ahead.
Thank you. I guess good afternoon, Your Honors. My name is Carol Frizzoli, and I represent the Department of Children and Families in this case. The trial court properly determined that clear and convincing evidence established Mother's parental unfitness, where Mother was not able to provide this child with the level of care she requires, and Mother was unlikely to become fit in this foreseeable future, and that ultimately it was in the child's best interest to terminate parental rights. As you are aware, there were 2 trials in this case. The department did seek termination in the first trial. And although the judge agreed that the mother was currently at that time unfit to take custody of this child, the department did not use its reasonable efforts in order to provide Mother the opportunity to reunify with her child. So after the first trial, the department offered, as my sister has spoken about, the parent aid for 6 months and also extended visits. Now, the parent aid, there is, again, findings and testimony about that while working with the mother, there wasn't that progression that they saw because, again, the mother would get frustrated on a particular issue. So the progress they were to make in that particular meeting did not work. However, the parent aid did assist in visits because she met with Mother on a one-on-one basis and then also helped supervise the visits with the ongoing social worker. Now, when we talk about Mother's cognitive delays, there is, in this particular, a nexus between that and her unfitness. Now, some of the visits, and this is not just based on the testimony of the department. What also was evident in this case was the trial court appointed a guardian ad litem, and there was a court investigator appointed. And again, the bonding expert, Dr. Merritt, was also part of the case and observing visits.
Right.
In fact, the GAL, which was appointed by the judge.
Counselor, the guardian ad litem said that Mother appropriately took unsafe activities from the child and redirected her attention when necessary. She opined that Mother made noticeable strides. So that doesn't seem like clear and convincing evidence of unfitness. Basically, you've got 2 or 3 visits where she was fixated on something else, but there was no danger to the child whatsoever. So where is there clear and convincing evidence of unfitness in this evidence here?
Certainly, Your Honor. So with respect to the guardian ad litem, further on, because one of the purposes of the guardian ad litem was to see if there was settlement and to look and see, because at that point there were supervised visits. And one of the conclusions of the guardian ad litem, after viewing 2 or 3 visits between the mother and the child, is that Mother had never progressed to a level where it would be safe for her to have unsupervised visits. So that was the ultimate conclusion.
Where is that in the findings?
Where
did the judge credit that?
In the guardian ad litem report, that was just a court document, Your Honor.
Where did the judge credit that?
I don't believe the judge, there were, oh yes, I believe finding number 326, where the GAL, where basically the trial court referred to the GAL's unsupervised visits would be extremely traumatic to the child. So in addition, Your Honor, it wasn't just the mother's cognitive abilities and the visitation. What also was really a primary factor in this case were the fact that mother lacked supports. The mother herself acknowledged that she would need assistance with the child, and she had no reasonable supports. The judge specifically found that mother's support plan, which was her mother and sister, was not a reasonable one. In addition, we have the child's special needs. This child had global delays. She had speech delays. She couldn't even be in a normal preschool program. What they had recommended was a therapeutic preschool for her. And she tantrumed. And mother, and there's many talking about the different visits on mother, how being not able to handle that tantruming. Because very often, as one of the major things that's you see in the bonding evaluation, one of the observations of the visits, the expert, Dr. Merritt, came to the house, or came to the program, which the mother had been placed at. And during that, she walked by the daycare center in that house, and the child became anxious and started hanging underneath the legs of the social worker. Mother didn't even notice. And that was a regular theme.
Counselor, where's that in the findings?
With respect to mother's, the findings number 345 and 346, which talk, it's number, that's what starts out as factually the stroller visit, I call it, which is finding number 322. But the bonding experts, Dr. Merritt's conclusions after that visit is at findings 345 and 346. So again, it wasn't just the department saying that mothers, didn't get to a level of unsupervised. We had a court investigator. And again, all of them came to that same conclusion, that it wouldn't be safe to have mother have unsupervised visits, not be able to parent this child on a full-time basis. So again, with respect—
Counselor, I see that in 326, the judge finds that the GL opined that unsupervised visits could be extremely traumatic. Judge doesn't credit that or say that she agrees with that opinion, but at least states that. Is there any place else that I'm going to find a finding in these findings that unsupervised visits would be unsafe or unwise?
Again, at findings 345 to 346, which refers to the bonding eval, which was an exhibit at trial. In that bonding evaluation, there is references, and the bonding, she comes to the same conclusion that this child, there shouldn't be unsupervised visits. And again, even the court investigation, which is a court document, which is not evident in the findings, but in the court investigation, which is part of the evidence in this case, she references that the visits which were in the community, you couldn't get a good measure of mothers. So she said after her recommendation, they moved the visits to the home.
Counselor, if you're telling me that there's evidence in this record, it's not in the findings, that shows unfitness, don't we have to send it back? How can we, if the findings don't show unfitness, how can we affirm?
Your Honor, I respectfully disagree that the findings don't show unfitness, because again, if you look at the culmination of all the factors, the ability of mother not to be able to, she doesn't have the skills to be able to deal with this child of special needs. There's findings from that basically mother herself acknowledges to parent this child successfully, she needs a support system. The trial court did not find that support system. That's finding 296. There is findings that about the social worker's observations. Most of the findings, again, are from 289 to 346, which show the unfitness with respect to what mother's abilities and her ability to manage during visits. So again, as my time is running out, this is not just what we also have to address is the reasonable efforts. The reasonable efforts do not affect the termination. That's the adoption of Iona case and adoption of Uday. Even if the trial court, if this court finds that the department did not use reasonable efforts, that does not usurp the termination of parental rights.
Counsel, how, in the judge's conclusions of law, she says in a couple of places, I think it's paragraphs 10 and 31, that the mother is unavailable. She uses the word unavailable instead of unfit. Do we know that she's using the right standard? And what about the fact that she doesn't cite to specific factors under Section 3C?
Yes, Your Honor, with respect to the case of adoption of, custody of Kaylee, Your Honor, talks about, it's not, although she doesn't specifically say 210, if Your Honor, in my brief, I cite it is, form over substance. She does detail pretty much the findings under 210 of 4 separate factors, which are relevant to this case.
One of the things I was confused about at page 40 of your brief, you said that the factors that were relevant here are 5, 6, 7, and 12. But as I read it, factor 5 is for a child under 4. And factor 4 is for a child 4 or over. And then you go on to say that this child is 4. So why wouldn't this be a factor 4 case instead of a factor 5 case?
I believe, Your Honor, that's an error in my brief. I should have factor 4.
At what point is the age of the child considered? Is it at trial?
Again, and I believe that's why, yes, it would be the age at trial. And I think she had just turned 4, Your Honor, prior to trial. So so I think it was the age we used based on trial.
Thank you.
Okay, thank you. Attorney Kiefer?
Yes, good afternoon, Your Honors. Mara Kiefer here for the child, AC. Child supports the termination of parental rights and remaining with her pre-adoptive family. Today, the child is 6.5 years old. Her 7-year birthday is coming up in June. She's in 1st grade, and she knows this pre-adoptive family as the only family she's ever known. She's been living with them since she was 2 months old. And so what I'm here today to do is to stress on behalf of the child that if a forced return of custody to mother were made, that it would be severely traumatic for this child, and it would not be in her best interest, number one. And number two, I won't get into the argument of reasonable efforts or a meaningful connection between whether or not the mother's mental health limitations has a nexus between her ability to parent the child. What I'm here to stress is the child's welfare. So I'm focused on the cases that talk about even if reasonable efforts were not made at this juncture, at 6.5 years of age, if a forced removal were to take place, or even a substantial change in the custodial environment, that severe trauma would result for this child. This child has her own substantial mental health deficiencies. She's on an IEP. She is struggling in school. She's in a special setting. Simple things like just going to the dentist are an arduous task. It takes hours to put her shirt on, her tantruming, and rises to very high levels. And she requires not only a competent parent, but professional care as well.
Counsel, could I interrupt? You know, I understand it's the best interest of the child. And I understand, you know, Attorney Bagnall made an argument that basically from the get-go, this child was removed from the mother, and it was, although not her words, they weren't going to give the mother this child. And so it's now been to a point where the child has been with the pre-adoptive parent, and any removal would cause some trauma. I mean, if the department didn't use all their available means to help the mother, couldn't this be a bad message we send by saying, take the child away and let them develop a bond, don't do anything with the mother, and then it's too late to try to give the mother the opportunity again.
And the court raises an extremely sensitive and genuine point. And yes, it could send a wrong message or a bad message if we didn't also balance the mother's rights against the welfare of the child. And we are where we are today. I mean, here we are, she's 6.5 years old. So really, what is the right thing to do at this point? This is a tough case. It's a really tough case.
What do we do with the fact that the findings are full of findings about the inadequacies of the pre-adoptive family? We have findings about missing daycare, being removed from the Quincy Public School daycare system, delays in getting early intervention services, 5 instances of injuries, the fact that the foster mother brings the child to work sometimes. We have all these findings of inadequacies, and yet there's no place in these findings where it explains why nonetheless this adoption plan is in the child's best interest, other than Dr. Merritt's opinion. Is that enough?
Well, I think that, so I think it's a 2-part question. Number one, did the pre-adoptive family have their own struggles? I do think they hit some rough patches. I think this child is a special child and required and still requires a tremendous amount of attention. And I think that some of those items like missing some daycare were fleeting, and I do believe that they were corrected. So I'm not here to say that the pre-adoptive family was perfect, but I think that given what they had, the resources that they did a pretty good job with this child. And I don't think there was anything found such as abuse or neglect or injury to the child or things that would warrant, changing the foster care. I think my time is starting to expire.
We'll let you finish.
So I really want to make the point that, all the cases say that the welfare of the child, it's the most important consideration in determining whether the parents are fit. I really don't think there's enough evidence in the record to support that the mother had the ability to parent the child. There were too many negative instances, things she just didn't understand, not through her own fault, but even while there's a supervised visit, the child having a wood chip in her mouth and her not knowing to tell her to take it out, and things like that would actually endanger the child.
Where was that's not in the findings, right?
I would have to flip through my brief, but I did cite that in my brief. The other thing I wanted to mention was that I'm really not.
Before you go on to another topic.
Okay.
When I said we'll let you finish, I meant the answer that you were discussing. But
okay,
your time has expired. We're gonna have to call it.
Yes, sir. Thank you very much.
And we are back live and on the record.
We've now reached the last case of our sitting for today. It's docket number 2019 P1690, RP versus JP. Attorney Gomes.
Good afternoon, Honorable Justices of the Massachusetts Appeal Court. My name is Attorney Nicholas Gomes, and I represent the defendant in this action. I am asking you to respectfully review a restraining order that was issued against my client going back to July 3rd of 2019 out of the Wareham District Court. From a procedural standpoint, that restraining order was extended during the pendency of this appeal, which was filed in December of 2019. And the extension date hearing of January 2nd, 2020 occurred, and the restraining order was not extended and terminated on that date of January 2nd, 2020. At the time of my filing this appeal—
Was there a hearing on the 2020?
Yes, Your Honor. It was a full hearing and both parties appeared.
And what was the, did the order, do you know if the order ordered that all records in the police department and the clerk's office be removed?
I do not believe that was incorporated into the order, Your Honor. But it's something that I'm looking at. So that time frame of January 2nd, 2020, I believe is instrumental to this case, because the plaintiff in this matter also filed an application for a restraining order with a hearing date of January 16th of 2020 that was found to not have probable cause. And that criminal complaint was an allegation of a violation by my client of this very abuse prevention order that I'm appealing.
But we don't have that before us. We don't have that docket or any of those entries about those events, right?
Yes, Your Honor, that is accurate. And the timing of those events were simultaneous to my December 2019 filing. So they were, and I veered to the court essentially that those were nothing more than further efforts to seek to get my client in trouble.
Right, but let's focus on your argument before us today, though.
Yes. So here, Your Honors, I would like to first go over the two main arguments. My first argument is that the lower court erred in assessing the credibility of the evidence. At issue in this case is a single act in an allegation that my client turned on a water spigot that caused property damage. And then my second argument is taking that fact as truth, that if my client did turn on that water spigot, the very fact of turning that water spigot on alone is insufficient to arise to the level of danger required under Chapter 209 to reasonably find that there was a substantial likelihood of immediate danger and harm. So first,
I have a question for you about your issue 1. At page 5 of your brief, you say that there's no credible evidence that the defendant committed the single act alleged in the appellee plaintiff's affidavit. Is that affidavit before us?
No, Your Honor. In here, it was not included in any documents provided by the court either, I will know.
Well, it was before the trial judge, or the district court judge, wasn't it?
Yes, Your Honor.
So why isn't it before us?
I do not know why the affidavit was there. There were several issues. I had to get the transcription redone on this case, and because of its urgency, I wanted it heard rather than creating any procedural issues of the documents being not in the courthouse. And I do not know why.
But how do we know there's not something in the affidavit that gives us that link?
In here, I made the judgment because of the transcript of the record seemed accurate, and the judge took special care with the pro se plaintiff to get her testimony at the hearing.
No, I understand, but doesn't a judge have the affidavit and the ability to have a live hearing and ask questions? I mean, doesn't the judge use both document and testimony to make his or her decision?
Yes, Your Honor, that's
So-
absolutely
so
standard.
We don't have everything. You're asking us to consider that there was insufficient information, and we don't even have one of the pieces that the judge considered. It may not contain anything more, but we don't know that.
Your Honor, I am comfortable before you today focusing on the record as created by the court and submitted to you, or submitted to me and then submitted to you.
But the record as created by the court includes that affidavit. In other words, if you look at Mass Rule of Appellate Procedure 18, that puts the burden on the appellant in any case to go to the clerk's office and get copies of whatever documents are relevant to the appeal and include them in the supplemental record appendix, because the appellant knows what the issues are. The clerk in the district court doesn't know what the issues are. And if the clerk leaves something out, like the affidavit that's necessary for us to decide the appeal, we don't know what's in that affidavit. For all we know, it says your client did something really terrible.
I would aver to the court that although it is regular practice for the district court to have an affidavit for the 209A form and that it should be included in the package, it was not included. And I do not have personal knowledge myself of reviewing the file and seeing an affidavit. So I would respectfully request to move forward on the case based on the record that was created, which is, and that only adds to my argument. If I may continue.
You can argue, but you can see that it's a concern of this court that we don't have the sufficient information to make a decision in this case.
And if your honors would allow, I would be okay with essentially following back up to confirm that very fact regarding this affidavit of whether it was lost, they don't have it, and why it was not produced. But here, looking at the argument before you and the error of assessing the credibility in this fact, here, the defendant is claiming that this claim of a water spigot being turned on is nothing more than a generalized apprehension of fear. Now, there was no evidence of actual damages that occurred to this house by that spigot. There was no photographs, no contracts with any cleanup contractors. There was no expenses regarding lost items. There was no
How do
civil.
we know all of that information wasn't in the affidavit?
Your Honor, the record that I have, in the same record that is before you, does not contain an affidavit. So we don't know if there is even an affidavit at the district court.
Well, at page, record appendix, page 11, the judge says, so this is the 10-day return on the order. Let me read your affidavit and I'll have some more questions. So the judge in issuing the restraining order had the affidavit.
I understand, Your Honor. And if that is the case, then I will do what I need to do to make sure you have that. And I would respectfully request the opportunity to do so.
Didn't you read the affidavit before this hearing?
No, Your Honor. Any affidavit was reviewed quickly right before the original hearing date, which is the general format of these hearings down in the Wareham District Court.
No, but did you review it then?
Your Honor, respectfully, I do not have a specific recollection in this case, but I do know that when I did obtain the court docket, I did not have it.
Well, I understand. Look at the clerk's office produces the assembly of the record and sends it to this court. When you're arguing a restraining order, a crucial piece of the evidence is the affidavit. The judge had to read it before he even considered the case. I guess our suggestion to you is that you should have reviewed the docket and said there's something missing and done some legwork before it reached this stage. I mean, we're not trying to be, I think the point has been well made. We'll leave it to whatever, but to suggest there is things that weren't included when you don't have the affidavit, we can't just accept that, is what we're saying to you.
I understand that. And my position is that I requested the docket and it was omitted or it wasn't there. So I continued in the course of what I did receive, which was the transcript, which I even had to correct errors in the transcript. So it was a hurdle.
So we'll let you finish your argument, but understanding that we do not have an affidavit and we may not be able to rule.
Understood. Thank you, Your Honor. Moving forward with the credibility in this case, there was no criminal complaint that issued against my client regarding malicious destruction of property. There was no, the police officers who arrived at the scene did not provide any type of 209A warning to the alleged victim in this case. The plaintiff came into the courthouse with hearsay statements that were self-serving and not supported by any other evidence. Here there was, and the plaintiff testified that there was no past history of abuse to her or the children. And without that history of abuse, for her to just come forward and claim this hearsay statement that the water spigot was turned on and there was damages without actual evidence is the issue.
Why is that hearsay?
Yes, I'm sorry. Her, you are correct, Your Honor. It is not hearsay. Her statements is what I meant to say there. Thank you. Now, weighing the evidence that was before the judge, my client came in with actual evidence, a disinterested third-party witness, as well as a document from her employer, which detailed the timeframes when she was working.
Counsel, you haven't given us that document either, have you?
That document was not, it was reviewed by the judge and not formally made a exhibit in the case. So here,
when you say it was a disinterested third-party witness, this was another woman who your client had spent the night with shortly after their breakup, the breakup of the plaintiff and the defendant. So do you want us to infer that she's disinterested?
Yes, Your Honor. And I know you can't, you don't, there's no visual record, but I aver to you that Miss Sheila Walsh is a very sick elderly individual, and this is nothing more than a friendship of why she was residing at the house. Now, the contention from the plaintiff is that during the overnight shift on the 15th, she worked from 10:30 at night throughout the night until 8 a.m. when she came back to her house and noticed the water. The evidence put forth for the defendant showed it was impractical, if not impossible, for her to be able to be at the plaintiff's home in Dedham in time to do this. She worked that night until 8 o'clock, which she left and came back to Bristol County. And from that point on, she was under the watch, you could say, of Miss Walsh, who testified to being up with medical related issues with her. So she would have been able to see if the defendant left the house or not. Looking at the distance and the time, it is impractical that it could have occurred for Mrs. Bertocchi to turn on the water spigot in between working both shifts on the 15th and the 16th. Here, we aver to you that this lack of evidence in comparison to Ms. Bertocchi showed a failure to prove beyond a preponderance of the evidence that the plaintiff could have been reasonably placed in fear. And I compare for the case law for you is the case of Smith v. Joyce. And the point is they had a history of threats leading up to the actual hearing. In this case, there's no past issues of harassment or any type of violence. It's the exact opposite. And in this case, there was the finding of such a high credibility with no past history. And I compare that.
I'm going to have to cut you off there. Your time has expired. We're going to take
Your honors.
Go ahead, Joe.
I got just one question. Could you explain your request for attorney's fees?
Yes, Your Honor. Here, I included a request for attorney's fees because I believe this is a bad faith attempt of the plaintiff in manipulating the court's processes. There was a previous harassment prevention order 2 months prior that I appeared in that there was no finding. And then she forum shopped, went to Wareham, and although it did issue, I believe there's evidentiary issues before you here today. And then going forward with the application for the criminal complaint. This is a pattern of activity on behalf of the plaintiff aimed at trying.
What authority is there for us to grant attorney's fees under that circumstance?
Your Honor, I believe this would fall under the realm of a frivolous use of the court.
But you're the only one using the court right now.
Yes, but it is necessitated by the lower court actions in the plaintiff's filings therein.
Are you arguing that your client was entitled to workers' compensation in this situation?
No, Your Honor. No.
All right.